Welcome to the deep dive. We're here to really get into the weeds of the law, element by element.
That's right.
Today, our mission is, well, it's a tough one. We're tackling a core question in criminal law. How far can a state go in defining what counts as criminal responsibility?
Yeah.
Specifically, we're looking at that intersection between due process and criminal intent, the mens rea. Can a state just decide, nope, a jury can't consider evidence that someone was blackout drunk when figuring out if they intended to commit murder?
It's a fascinating clash, isn't it? You've got this deep-seated moral view about drunkenness running headlong into the modern rule that the prosecution has to prove every single piece of the crime.
So how are we going to tackle this?
We're going to really unpack the Supreme Court's big decision from '96, Montana v. Egelhoff.
Cool.
First, we need to figure out what constitutional test even applies when you challenge a state's criminal rule like this.
Okay.
Then we'll run Egelhoff through a structured analysis, a FIRAC method, paying close attention to the history and the policy stuff that really split the court.
Right, because challenging a state law on due process grounds is notoriously difficult. It's a high bar. Before we jump into Egelhoff's facts, what is that fundamental rule? What's the test for saying a state restriction violates a fundamental principle of justice?
The burden is, well, it's huge. You, the challenger, have to prove that the state is restricting here. Using intoxication evidence to argue you didn't have the required mental state is, and this is the key phrase, so rooted in the traditions and conscience of our people as to be ranked as fundamental.
So rooted. Okay.
Yeah.
That sounds deliberately difficult to prove.
It is. It essentially means you have to show your proposed right is more historically embedded and widely accepted than the state's rule you're attacking. It's a heavy lift.
All right, let's put that test to work. Let's analyze Montana v. Egelhoff. It dealt directly with a Montana law, section 45.2.203, that said voluntary intoxication cannot be considered for mens rea. First, what are the legally dispositive facts?
Okay, the respondent is James Allen Egelhoff. He'd been on a serious drinking binge camping in Montana. Later, he's found in the back of a station wagon. His blood alcohol content, even measured hours later, was 0.36%. Just staggering.
Wow.
And in the front seat, his two companions, Pavola and Christensen, are dead. Both shot once in the head. Egelhoff's .38 caliber handgun is nearby. Gunshot residue is found. So he's charged with deliberate homicide. Now, under Montana law, that requires proof he acted purposely or knowingly.
It's highest levels of intent.
Exactly. And his entire defense was, I was so incredibly intoxicated, I simply could not have formed that specific mental state.
And what was the core legal issue the Supreme Court had to decide?
The precise legal question was, does the Due Process Clause of the 14th Amendment bar a state from enacting a statute that forbids the jury from considering voluntary intoxication when deciding if a defendant had the required mental state, that purposely or knowingly element?
What rule of law did the court apply? You mentioned the fundamental principle test, but how did the plurality break that down for this specific analysis? What were the elements they looked at?
Right, so the plurality used that core fundamental principle test, but they structured their inquiry around really three intertwined elements or factors to see if this right to use intoxication evidence was fundamental. These were, one, the really long history at common law regarding intoxication.
Okay.
Two, how uniformly or not this kind of rule allowing intoxication evidence had been adopted across the states more recently.
Uniformity, got it.
And three, whether there were valid policy justifications for Montana's rule disallowing the evidence.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the plurality apply the first element, the lengthy common law tradition?
Well, they looked way back, centuries back, and they found the common law was pretty decisive against using intoxication as an excuse. They pointed to big names, Hale, Koch, Blackstone.
The heavy hitters.
Yeah. And those jurists didn't see intoxication as lessening guilt. They saw it as an aggravation of the offense. The old rule was strict. The drunk offender gets the same judgment as a sober one.
So no excuse there.
None. The plurality argued this history was so old and so clear against allowing the excuse that it strongly suggested the opposite rule, the one Egelhoff wanted, couldn't possibly be fundamental.
Understood. Now, what about the second element, the emergence of the 19th century exception? Because Egelhoff's side argued things had changed, right?
Exactly. This is where it gets really interesting. The defense pointed to the 19th century, arguing the common law did evolve. They identified this specific intent exception traced back to an English case from 1819, which did allow juries to consider intoxication, but only for crimes needing a specific kind of intent, like premeditated murder.
Okay, so a newer rule emerged. Why didn't the court buy that this newer rule was fundamental?
The plurality basically said, too little, too late. They argued this 19th century rule was, quote, of too recent vintage. And critically, it lacked sufficiently uniform allegiance across the United States.
Meaning not enough states had adopted it.
Right. They noted that about a third of the states either never adopted the specific intent exception in the first place, or, like Montana, had actually ditched it recently. So, because it wasn't old enough and wasn't universally accepted, the court concluded this 19th century exception wasn't so rooted as to be a fundamental right.
Finally, what were the policy justifications the court considered for upholding Montana's traditional, stricter rule?
Yeah.
The third element.
These were really important for bolstering the state's position. The court found several strong policy reasons. First, deterrence. They cited stats suggesting a huge link between alcohol and violent crime, especially homicide. Maybe up to half of them involve intoxicated offenders.
Wow.
Half. Yeah, it's a striking number. So the thinking is, if you don't let intoxication be an excuse, it might deter people from getting drunk and violent. Second, specific deterrence, making sure people who do lose control because they chose to drink heavily still face consequences, like prison.
Accountability.
Right. And third, moral culpability. The court said the rule reflects a deep-seated societal view that if you voluntarily impair your own judgment and faculties, you should be held morally responsible for what happens next. The existence of these strong policy reasons, the court said, further undermines the idea that the opposite rule could be fundamental.
And after analyzing all the elements, the ancient history, the lack of modern agreement, the strong policy reasons, what was the court's final conclusion?
The bottom line was that Montana's law was constitutional. The Supreme Court held that the Due Process Clause doesn't stop a state like Montana from deciding that voluntary intoxication is irrelevant to mens rea. Defining the elements of crimes is primarily a job for the state legislature, and the right Egelhoff claimed wasn't fundamental.
Now, this is where the case gets even more complex, because the court wasn't unified. Justice Ginsburg agreed with the result of holding the law, but for a totally different reason. She saw the Montana statute differently, didn't she? How did her characterization differ from the plurality's view of it being an evidentiary rule?
Yeah, Ginsburg took a completely different path. She basically sidestepped the whole debate about whether excluding evidence was constitutional. She looked at where the statute was placed in the Montana Code, not in the evidence section, but in the part defining general principles of liability.
Location matters.
For her, it signaled that Montana wasn't just tweaking evidence rules, it was making a fundamental legislative judgment about culpability itself. It was redefining the crime, effectively saying, for purposes of deliberate homicide, acting while voluntarily intoxicated is the legal equivalent of acting purposely or knowingly.
So a redefinition of the mental state.
Exactly. And since states have enormous freedom to define the elements of their own crimes, if Montana simply redefined mens rea this way, then evidence of intoxication becomes legally irrelevant, and there's no due process problem. It's a cleaner constitutional argument.
That distinction, is it an evidence rule or a redefinition of the crime, seems crucial. Justice Breyer, in dissent, really pushed back on this redefinition idea with a pretty stark hypothetical. What was his point about the potentially weird or unjust results if we treat the law as a redefinition? He used two drunk drivers, right?
Right. Breyer argued that calling it a redefinition without the legislature explicitly saying so creates serious problems. His hypo highlights this. Imagine two drivers, both equally blackout drunk. Driver A unknowingly floors it through an intersection and kills someone.
Okay.
A jury, blocked from considering his intoxication, looks at the result, dead pedestrian, and easily infers the required knowledge or purpose for homicide. Convicted.
Right.
Driver B, just as drunk, unknowingly drifts and sideswipes an empty parked car on the highway. The result isn't death. The jury, even without intoxication evidence, might only infer negligence or maybe recklessness, lesser offenses. He might get acquitted of a homicide-level charge.
So identical mental states, wildly different outcomes based on what?
That was Breyer's point exactly. Guilt or innocence, and a potential life sentence, hinges on irrelevant external circumstances, hitting a person versus hitting a car, rather than the defendant's actual, albeit impaired, state of mind. He argued this shows the state hadn't really redefined the mental element properly. It just took an evidentiary shortcut with unfair results.
That really clarifies the tension.
Yeah.
Okay, let's synthesize this. For you listening, maybe prepping for an exam or just trying to understand this area, let's distill this into an actionable diagnostic checklist. How should someone approach analyzing a state criminal rule like this when it's challenged under due process?
Okay, great idea. Here's a kind of step-by-step way to think through it based on Egelhoff first. Identify the state's action. This is key. Drawing from that Ginsburg plurality split, ask, is the state characterizing this law as merely excluding evidence for policy reasons? Or is it claiming to have fundamentally redefined an element of the crime itself? How the state frames it matters.
Step 1, exclusion or redefinition. Got it.
Second, determine the impact on mens rea. Look closely at the crime's required mental state. Does the state demand a subjective state like purposely or knowingly? If yes, does this rule effectively block the defendant from offering any real defense to negate that specific element? If it does, that raises a big due process question mark.
Step 2, impact on proving the required intent.
Okay. Third, apply the fundamental principle test, if evidentiary. If the state's rule is framed as an evidence exclusion, then you have to apply that really tough Egelhoff standard. Is the right to introduce this specific evidence like intoxication so rooted in the traditions and conscience of our people as to be ranked as fundamental? Remember, Egelhoff's plurality suggests the answer is likely no for intoxication, pointing to history, lack of uniformity, and policy.
Step 3, the high bar of the fundamental principle test.
Right. And fourth, check for requisite state definition. Now, if the state argues it's a redefinition, like Ginsburg suggested Montana's law might be, you have to ask, has the state's own highest court actually interpreted the law that way? Federal courts generally have to accept the state high court's interpretation of state law. If the state court says, no, this is just an evidence rule, then you're back to step 3 and the fundamental principle test.
Step 4, did the state actually redefine it according to its own courts? Excellent framework.
Hopefully that helps structure the analysis.
So wrapping this up, what's the big picture takeaway here? Feels like we're left with this unresolved tension between very old ideas about moral blame for drunkenness and modern constitutional rules about proving guilt.
Absolutely. Egelhoff starkly shows that huge battleground. States have immense power to define what makes someone criminally guilty, and as a result, about a third of the states currently have laws that, arguably, make it impossible for a defendant to contest a key element, their mental state, if they were voluntarily intoxicated, even extremely so.
It really forces us to keep asking that hard question.
Right. When does a state's rule, even one based on understandable policy goals like deterring drunk violence, go too far? When does it stop being a procedural tweak and start undermining the core constitutional right to present a defense and hold the prosecution to its burden of proof?
And one final thought, maybe something for you listeners to chew on. The plurality in Egelhoff briefly mentioned some evidence suggesting that violence linked to drinking isn't just about the alcohol itself, but might involve a cultural element, learned behaviors or expectations about aggression when intoxicated.
That social component.
If we take that idea seriously, that becoming violent when drunk is partly learned behavior, does that actually strengthen the state's argument? Does it make it seem more justifiable from a policy or moral standpoint to say, look, you chose to drink, knowing these potential learned behaviors might surface, so you are fully responsible for the outcome, regardless of your precise subjective awareness at that exact moment?
That's a provocative question to end on. It adds another layer to that moral culpability argument, doesn't it? Something to definitely think about.